Good afternoon, and if you're on the West Coast, good morning. This is Bill Bronchick. Welcome to Webinar Wednesdays, where we talk about cutting-edge real estate, legal, business topics that can impart hopefully some good advice and information for you that you can take and use right away in your real estate or small business. Today, we'll be talking about using land trusts for privacy and protection. And if you have questions as you go, there are a few ways to do it. You can go into the Q&A and post a question, or you can post it in the chat, or I think there's a way to raise your hand and I can make you live, but I'm not positive about that. So we'll skip that and go right to questions in the Q&A as well as in the chat box. So I'll check those from time to time as we go through the webinar. I really like land trusts. I've been using them for 25 years, maybe even a little longer than that, maybe a little closer to 26, 27 years. And I've had a lot of success with land trusts in a variety of ways. A land trust is a very powerful tool if used properly and if you understand what it can do and, of course, what it can't do. I will discuss one of the limitations or two of the limitations of land trust and a lot of the benefits as well in using it for privacy and protection, particularly in your real estate business. You know, my goal for you in this presentation is to learn the concepts of land trusts and be able to take action on it as soon as possible. I find that if you take action on it right away, you're more likely to have effectiveness in what you do and how you use it than if you just put it on the shelf and wait for the next webinar that I do in 6 months. So in real estate, there's what you know, what you don't know, and unfortunately what you don't know that you don't know. And usually when you're in court in front of a judge telling you what you don't know that you don't know, don't be one of those people. Learn what you know, what your limitations are, what you don't know, and understand there's a whole area of what we call the blind spot, what you don't know that you don't know. And if you don't know that there is an area called what you don't know that you don't know, you are what we call dangerous. I know what I know and I don't know. And when I do a new business area or a new area of my life, I recognize I don't even know what questions to ask. I know so little. So don't be one of those people. You're probably familiar with the golden rule of law. He who has the gold, no, wait for it, gets sued. If you are likely to have assets, especially significant assets, if you flaunt what you have, if you don't keep private what you have, you're more likely to get sued. And that's just the way the game works. People who are broke, or at least appear to be broke, you ever meet these millionaire next doors who drive a crappy old truck and live in a basic house, and you never know they're worth $10 million. There's something to be said about that. You don't drive your Mercedes Benz to pick up your rents. You don't want the tenants to see that, because they think the landlord is rich because he owns property or she owns property, and they're not, and therefore, there's something wrong with this equation. You hear it a lot in political discussions about income inequality or wealth inequality. And, that's the way we work in a capitalist society. There are people who make it, some people do inherit it, some people do cheat. I get that. For the most part, people who are wealthy and successful got that way by doing things that poor and broke people don't do. And they have different disciplines, they have different work habits, they have different work ethics, and they've, for the most part, earned it. And people who are broke, for the most part, I wouldn't say it's all their fault, but if you're born broke and you die broke, then that's your fault because you have a choice in life. So you got to deal with that mentality. And people who walk around flashy watches, notice I don't have, flashy cars, drive your Benz to pick up your rents. They have what's called the foreclosure Ford. Everyone should have one of those, a beaten up old Ford minivan that you go pick up the rents in or negotiate houses with. So a lot of people, when they are thinking about suing a landlord or someone else, will go to a lawyer like this. Most people who are broke don't have money to pay a lawyer by the hour. So they're going to look for what's called a contingency fee lawyer, also affectionately known as an ambulance chaser. And they have ads like this: has someone injured you, car accident, train wreck, dog bite, mosquito bite, call 1-800-LETS-SUE. So they go down to the law offices of Dewey, Cheatham, and Howe, my brethren in the business. And how does this work? Typically, when you go to a lawyer, they're going to say $10,000 retainers, $400 an hour, no guarantees. This type of lawyer works differently. They work on what's called the contingency. That's what we call them, contingent fee lawyer. Meaning they'll say something like, well, Mr. Tenant who wants to sue Mr. Landlord or Ms. Landlord, we're not going to charge you any money up front. We're not going to charge you hourly. We're not going to make you pay for costs of investigation, court costs, expert fee witnesses, etc., and related fees. And if we win, our fee is 1/3 of everything we collect. Now, understand that it's not 1/3 of what you win. It's 1/3 of what you collect. So before Mr. Dewey wants to take the case on behalf of you with his law firm and expend money, time, and energy, they want to be certain of what? Well, the obvious thing, that there is a pot of gold at the end of the rainbow here. There is a way to get paid because they're getting 1/3 of what they collect. So before they sue, they want to be guaranteed a pot of gold. Now, typically the pot of gold is insurance, but insurance only covers what insurance covers. The insurance doesn't cover everything. A lot of things are excluded from coverage. So therefore, if there's no insurance coverage that's obvious, the lawyer at Dewey is going to want to know, well, what does this potential defendant own? The first thing they're going to do is look up who's the owner of the property the tenant's living in. And then they're going to search that name of the owner through the records to see what else he or she owns. And, you know, in this case, it's look at all this real estate and you're totally exposed. All they have to do is take that judgment recorded from the civil court records into the real estate records and get a lien against all of the landlord's property. Okay? So this is not a very good model, owning property in your own name. It's instant liability because if you are the owner, you are liable for everything that goes on the property. You are also liable for negligence claims if you actually show your own properties. You can be sued for discrimination. You can be sued for lead-based paint claims, et cetera, et cetera, et cetera. So owning everything in your own name is a mistake. So what a lot of people do is they'll put everything into an LLC. And an LLC is not necessarily the best move. I'm not saying don't use an LLC. We'll get to that in a little bit. But an LLC is public record with the Secretary of State. They want to look up the owner of the LLC. Your name's all over it. So that doesn't really accomplish anything in terms of anonymity and privacy. So what I discuss is different ways you could title assets in this section here. So number one, you could put it in your own name individually. That's pretty dumb. You could hold it jointly, which could be twice as dangerous. If you have someone's not your spouse, maybe a partner or a friend or a relative, you're not only exposing your property to your own problems, but to their problems. So that's not a good idea either. You could put it in an entity, such as a corporation, LLC, limited partnership, etc. That's a very good choice because it protects you from liability, but it doesn't give you anonymity. And then there's a trust. The nice thing about a trust is not recorded anywhere. There's no public filing of a trust, just the deed that goes from seller to the trust, or if you already own it from you to the trust. The trust agreement is never recorded. A trust is not an entity like a corporation or LLC. It doesn't file with the state. It doesn't have a tax ID number in most cases or a bank account. It's an agreement. A trust is an agreement between parties. That's all a trust is. So what a lot of people will use a trust for their estate planning and put all their properties into the Robert C. Jones and Mildred A. Jones Family Living Trust. Now, this doesn't really accomplish what we're trying to do, which is anonymity and protection, because one lawsuit on any property exposes the entire trust to all the problems, because it's only one trust. And two, Robert C. Jones and Mildred A. Jones, is there any mystery as to who the real owner of these properties are? It's Robert and Mildred. So the point of this is to avoid probate, which is a state court proceeding when somebody dies to probate a will. If someone leaves, if Robert C. Jones and Mildred C. Jones had a will that left all their properties to their children, you'd have to go through a probate proceeding to prove the will, to administer the estate, and it could take a while and it's very expensive. So a living trust avoids probate of the assets that are in the living trust. Especially if you own properties in multiple states, you got to do probate in multiple states. Whereas tying them all into a living trust in one state skips probate and passes it directly through the trust to the heirs. Very effective, okay? However, for probate it works, but not for anonymity or protection in this case. So this is not a proper way to do it. What I like to do is put each property into a specific type of trust, which we call a land trust. Each property has a separate trust, one property per trust. And the reason for that is multiple fold, if that's a word, multiple fold. I guess there are a variety of reasons is a better way of saying it. Number one, if they search the owner of the property, one, and that's where the tenant lives, they're going to see Land Trust 1. It's not going to be called the Robert A. Jones Family Living Trust. It'll be called something after the property, something anonymous like 221 South Winding Road Trust, 444 East Oak Street Trust. The trustee will be not you. We'll get to who that's going to be in a little bit. And then the beneficiary is total secret. Nobody knows who's behind the trust. It's sort of like the little man in the Wizard of Oz in the green curtain there. It's very effective to use a different trust-free property because if they search one trust name through the real estate records, they're not going to find any other properties owned in that trust. There's no pattern to follow. Each property is held in a separately titled trust, which is very effective. Now, this isn't necessarily for estate planning. We'll get to it a little later how you do estate planning. Land trust is not intended for that. It's intended for privacy and protection. So in this case, if they look up the ownership and try to find what you own, it's kind of like Catch Me If You Can, which is very, very effective. And, there are many benefits to land trusts. One is it discourages lawsuits, the golden rule of law. If they can't find anything at Dewey, Cheatham, and Howe, they're not likely to take the case on a contingency, so the plaintiff or prospective plaintiff goes home with his tail between his legs. Okay, it's sort of like the game of football. We're playing defense and they're playing offense. Dewey is the quarterback. If we can get rid of the quarterback, we take the ball and go home because they forfeit. So in that analogy, we're playing a game and we're playing it to win. And the game here is let's make it as difficult, confusing, and muddy as possible for the would-be Deweys of the world to discourage them from bringing litigation. I'll tell you a quick story. I had a client who sold a property. And in the process, the property was in foreclosure, and then it was in bankruptcy, so we weren't really sure what the amount of the liens were as a first and a second. I was doing the closing as the attorney, and I contacted the second lender, and I got a payoff amount, which I relied on to do the closing. The property was owned by a land trust. The beneficiary, frankly, I don't remember or know because it was the client's other entity, LLC corporation, something like that. I don't really recall, and it's not important, as I'll explain. So a few weeks later, I get a call from the title insurance company that I underwrote it through, and the attorney said, we got a problem with that closing that you did. I said, what's the problem? He goes, well, the payoff, they said $11,000. It's not $11,000. It turns out to be $67,000. And I said, wait a minute. I relied on their payoff. I'm good here. And he said, oh, you're fine, but we think your clients knew, and we think they took advantage of the situation, and we're going to sue them. So before the lawsuit starts, we have a sit down with the title company attorney and his client, one of the executives at the title company, myself, and my clients. And they start asking, well, what's this trust? What type of trust is it? I said, I don't know. They said, well, who's the beneficiaries? I said, I don't know. And I honestly at the time didn't know. So I said to the lawyer, I said, I do know one thing though. If you roll the dice and file a lawsuit and you find out that if you peel back that trust, there's nothing to go after underneath, you're going to spend $25,000 or more of your client's money. You're going to look awfully foolish. And he looks at his client looks at him, and they whisper something, and they stand up and they walk out. And they said, all right, fine. And they gave it up. And that was really powerful because it was the uncertainty of knowing a guarantee of whether they could have collected because they didn't know what was underneath the trust. And that was very, very important. Now, once they get into a lawsuit, they could discover who's underneath, but prior to the lawsuit, they cannot. It protects you from title claims. This is a real eye-opener if you've never heard this before, so pay careful attention. A lot of people sell property and they use a warranty deed. What does a warranty deed mean? A warranty deed contains a warranty of title. It guarantees that unless disclosed on this document, there are no liens or claims against this property. That's usually why it says it's subject to homeowners association rules, county regulations, and unpaid taxes for the prior tax year because taxes accrue, but they're not paid until the following year. So you have to say on the deed, except for taxes accrued but unpaid, otherwise you're breaching the warranty by not disclosing that. So if any of that turns out to be untrue, whether the seller knew it or not, Whether the seller caused it or not is irrelevant. The warranty is absolute. It's like a warranty of a product. You don't have to prove the product was intentionally made defective or the manufacturer knew it was defective, just that it was defective. So that's sort of like what we call in the law strict liability. Seller deeds the property and gives a warranty of title to the buyer. Now, the buyer may not accept the risk of getting a warranty from a seller without something to back it up. Like Dewey, they want a pot of gold to collect if the warranty is breached. So it's typical that a title insurance company will be involved. The seller will purchase title insurance, but the seller's not the insured under the policy. Who is? Well, it's the buyer that's the insured under the title insurance policy. So, pay attention here. This is really important. If there's a problem, let's say after closing, 6 months later, the buyer discovers a lien that was not disclosed or a title defect that was not disclosed, the buyer is going to seek recourse against the title insurance company who insured him. Remember, the seller is not the insured, the buyer is. The title insurance company will pay to fix the claim, and then what they do is they inherit that claim that the buyer had against the seller under the warranty deed for breach of warranty. That's what's a process known as subrogation. Subrogation, your $50 legal word for the day. So almost every insurance policy has the right of subrogation in it. If they pay a claim, the title insurance company or any insurance company in an insurance claim inherits the insured's rights, their claim against who caused the wrong, and then they go after that party. So the title insurance company then sues the seller for breach of warranty. Now think about this. I didn't know this, by the way, for years and years and years. I did not know this. I thought as a seller, it's customary to buy title insurance that I'm buying a protection. No, you're buying protection for the buyer. The buyer makes a claim, the title insurance company inherits the buyer's claim for breach of warranty, then sues the party at fault, i.e. the seller. So you're not buying in protection, you're buying a lawsuit. I'm not saying don't have it, it's a necessary evil, but understand you're not protected by that title insurance policy. So protecting it from title claims is important because I had a situation where I sold the property in Florida, and during the gap, which is the time between you sign the deed and it gets recorded, the property had a lien placed against it from the city that I didn't know anything about. Apparently, there was some sort of violation that I didn't know about because I lived out of state. And in fact, the address on the property was one of those postal mailbox places that went out of business one day. It wasn't a UPS store, it was a private one. And you don't get mail forwarding from private mailbox. Didn't know that either. So apparently they mailed a notice that I never got, and then they had a trial in my absence, and I lost for violation of the property code. They filed a $14,000 lien in the gap, and then 6 months after closing, I get a call from the title insurance company that I bought title insurance through. I believe it was First American, but I can't remember. And they said, well, the buyer had this lien show up, and we paid it, so now you owe us $14,000. I said, wait a minute. I bought a title insurance policy to protect me. They said, no. The title insurance company protects the buyer. We paid the claim on behalf of the buyer, and now we have their right to sue you under the warranty deed. And I was just befuddled. I just didn't understand it. I looked it up, and they were right. They were absolutely right. I always thought I was protected as the seller, but I'm not. But the good thing was the seller was a land trust. It had just conveyed its only asset 6 months earlier, so there was nothing to go after. And I managed to settle it. They were being a bit of a hump, and they were threatening to sue me anyway, even though they couldn't. So I settled it for about, I don't remember, maybe $2,000, which was a real win because they wanted $14,000. You can see how effective this is. Number 3, financial privacy. If you value your privacy in today's information age, you might think I'm being paranoid, but who's watching you? Your competition? Do you want to see them to see every property that you own and the pattern of buying and flipping and wholesaling and all that? The media, not exactly friendly to real estate investors. They call us vultures. An ex-spouse, attorneys like Dewey, Cheatham and Howe, the government. In my jurisdiction where I own a lot of rental properties in that city, if you get as a landlord more than 2 code violation notices within a 6-month period, you have to go to court. And the judge could fine you, throw you in jail. I'm not kidding. They could literally throw you in jail for violating the property code bad enough over and over again. If you own 10 properties in one entity or your name, then all of those are subject to the 3 notice rule. So it says 3 notices in a 6-month period on any number of properties. But if each one was owned by a separate trust, It's very hard to get 3 notices on one property because each property is a separate owner. Then the rule is 3 per property, not 3 per owner that owns multiple. I hope that makes sense. So very, very, very important. Now, some trust basics. Let's step back a minute and see if you understand how this works. A trust is a contract, as we said before. It's not an entity. You don't form with the state. You have the grantor who creates the trust, the trustee who manages the trust assets, and the beneficiary or beneficiaries, if they're multiple, whose benefit the trustee is managing it for. Now, in the context of the type of trust we're dealing with, the beneficiary and the grantor will be one and the same. That's what is known as a self-settled trust. So you create a trust for your own benefit where you're the grantor and the beneficiary. So there's only 2 parties, the grantor / beneficiary and the trustee. There are different categories of trust. There are living trusts, also known in Latin as inter vivos, between the living. So since it's a contract, the contract is between living parties versus testamentary trusts, which are created upon your death. How would you do that on your death? How would you sign a trust agreement? Well, your will could say that I leave everything to my grandchildren, but if they are under 18 at the time I die, a trust will be created for those beneficiaries. And that's how you do a testamentary trust. There are revocable and irrevocable trusts. Now, obviously, a testamentary trust is irrevocable because you can't revoke it after you're dead. But living trusts could be revocable or irrevocable. What does that mean? If it's irrevocable, you're saying, I create it and I can't take it back. I can't edit it. I can't terminate it until the trust purpose is fulfilled. I can't change beneficiaries. I can't do all that stuff. A revocable trust, you can do all those things. You can terminate it, take it back, give it away, edit it, change beneficiaries, and so forth. So what we're dealing here is a revocable living trust. You may have heard that before in estate planning. A revocable living trust. Some of you may even have one. That's a category, not a type of trust. There are multiple trusts in the category of revocable living trust, and one of them is, of course, the land trust. And by the way, when you're talking to title companies and brokers and attorneys, don't say land trust, unless you're in a land trust statutory state like Florida or Illinois, where it's very common. If you say land trust, their head will explode. Just say my revocable living trust. That's all, like they know the difference. So, revocable living trust. And creating the land trust is quite simple. Number one, we need to choose a trustee. Let's talk about for a minute who that should be. Ideally, in most cases, it's not going to be you, especially if your name is going to be on the deed as trustee. We'll talk more about that in a bit. A trustee ideally would be someone you trust, who's got enough sophistication and trustworthiness, that has a different last name, like a friend or relative, and ideally lives far away, out of the state or even out of the country is even better. Because the farther they are away, the harder it is for Dewey to serve a summons and a lawsuit on them. Now remember, a trustee can reside for addresses at a P.O. box. A corporation or LLC cannot. A corporation or LLC needs what's called a resident or registered agent within that state, where it was formed in every state it does business. That is a physical address. That way someone can serve a summons and a lawsuit at a physical address on a physical person or company. A land trust, in fact, most trusts don't require any registered agent or physical address. So that just makes it more complicated for Dewey to try to get information. Right? There's no public place to look up the beneficiary. This is just a P.O. box for a trustee. It's a different last name, confusing, muddy, convoluted, good. That dissuades him. Then we execute the trust agreement between you as settlor or grantor and beneficiary and the trustee. So you're the beneficiary and grantor, and then someone else is the trustee of the trust. And then we fund the trust. Now, if you've dealt with a living trust, you may understand what funding means. And if you don't, funding means putting assets in the name of the trust. So many people set up living trusts for estate planning, and then they don't bother to transfer their home or their car or their bank accounts. And if you don't put those assets in the name of the trust, they go through probate. They don't avoid it like you're trying to do. And likewise, with a land trust, you have to fund the trust by putting a property in the title of the trust or the trustee's name, okay? So if you already own a property, whether in your own name or in an LLC or co-owners, you would deed it from that entity to the trust. If you're buying a property directly in trust, then the buyer on the contract's the trust and the seller signs the warranty deed directly to the trust, okay? Just as an aside here, if you buy a property with Fannie, Freddie type of financing, they don't allow trusts to take title at closing with a loan. So you'd have to close in your own personal name, and then after closing, quit claim it over or warranty deed it over to the trust, which leaves a paper trail, not ideal, but better than leaving it in your own name. If you're buying cash, seller financing, private money, hard money, or even a commercial bank like a branch bank, they'll probably let you do it directly into a trust, okay? So your name never hits the records. Changing beneficiaries is quite easy under the trust. You do what's called an assignment of beneficial interest. What is that? Well, imagine you owned stock in an S Corp and you were the sole shareholder, and that S Corp owned a property. You could transfer the property from the S Corp to your buyer, or you could transfer the stock in your corporation to the buyer. That's like an assignment of beneficial interest. The trust owns the property, the beneficiary changes, which changes effectively the property. That is not recorded publicly. Neither is the S Corp thing I said, or if it's an LLC changing members, or if it's a trust changing beneficiaries. So nobody knows about that transfer except for you and the party involved, not the public eye. It's the same as the sale of property for tax purposes. Understand this. A revocable living trust is known under the Internal Revenue Code as a grantor trust. A grantor trust, what does that mean? That means the grantor is still the owner for tax purposes. So if you have a property you own in your own name, or you and your spouse, and you transfer it to your revocable living trust, that's a grantor trust. You're not going to report on the trust as a tax return. Trust doesn't file a tax return. The grantor still claims it as if he owns it outright. And that's the rules under the Internal Revenue Code. And you may know this if you have a living trust, that if you transfer your properties into the living trust, you still claim it as the owner of the property, even though title is in the trust. And if you change beneficiaries, then the taxable ownership goes with it. So if I'm the grantor and I create a trust agreement with myself as beneficiary, I'm still the owner for tax purposes. If I change beneficiaries from me to a third party, then they're the owner. It's just like if I deeded it directly from the trust, but I have it, it's still in the trust name. If I transfer the beneficial interest in the trust from me to my LLC, then my LLC would claim ownership of the property and so forth. Understand that a land trust is not a liability shield for most lawsuits. Now, I mentioned earlier the situation with the warranty deed and the breach of warranty, that's a contractual type of claim. So liability for unpaid assessments and under an HOA, or unpaid contractor, or a breach of warranty. Those are all contractual type of claims, and a land trust will take the hit and absorb the liability, and the beneficiary or beneficiaries won't be liable. But for an injury, negligence, fraud, misrepresentation, discrimination claim, that claim goes directly through the trust to the beneficiaries. The beneficiaries are liable. So the land trust won't be a shield like an LLC, which is why the trust beneficiaries, we should consider who they're going to be. A person or persons, a corporation that would protect you from liability, or an LLC that would also protect you from liability. Okay? So if you have an LLC, for example, as the beneficiary, the trust has a layer of protection for contractual claims, for anonymity, for people who file a lien. Let's say someone gets a judgment against you or your corporation. If they recorded that in the county where your property is owned in your name or your corporation, that judgment attaches as a lien to the property. If they sue your corporation and get a judgment, or your LLC, and they record that lien in the county where the trust owns the property, the trust is a different owner than the LLC, and therefore the lien won't attach. So it's very effective. In fact, the IRS set up these rules about not reporting because they assume that if you could revoke the trust, you're still the owner, so keep reporting it as if you're the owner. If the IRS had a problem with your taxes and they filed a lien in the county in which you own property, and that property was already titled in a land trust, the lien wouldn't attach to the property. And the IRS wouldn't know this because they told us, don't tell us about the trust because it's revocable, report it as if you own it. They set up the entire rules that will screw them in the long run. So we have two layers. We have the land trust for anonymity and certain types of lawsuits, and then we have the LLC below it for the more serious type of lawsuits. So it's not LLC or land trust, it's both. Okay, let me take a question here. Matthew asked, if I get a loan in my name and then I move the property into a land trust and LLC, is my information still private or does the loan in my name make it public? It's a good question. So the property is not tied to you. If someone looks in the assessor records, they're going to show the current owner being the trust. If they do a title search, a chain of title in the clerk's records and go backwards, they could see that you used to own it and now it's in the trust name. Now, Dewey may make an assumption that you're somewhere underneath in terms of ownership, or they can make the assumption that you sold it. Either way, it's confusing to Dewey. And Dewey is not likely to take that case on a contingency, so you understand? We won the game. That's the game we're playing. Matt also asks, same question, I'm sorry, he asked it twice. Let's go to the Q&A chat here. Catherine asks, I thought here in North Carolina, the certifying attorney is responsible for any mistakes they make on title. Well, sure, but what mistake did the attorney make when the example I talked about where they did a title search, they did a closing, and between the time I signed the deed and it was recorded by the title company, a lien came in the gap. They wouldn't know that. They're not going to search it again in the last minute again. So they wouldn't be responsible necessarily for that because they didn't miss the lien. It just wasn't there at the time they searched. You know, there's just bad timing. Vincent asks, when I open a bank account, will it be in the trust or LLC name? LLC name. We'll get to that in a little bit. Kyle asked a great question. Is there any liability on the trustee's part? Well, trustee is generally not liable for things that go on the trust property, the trust assets, except if the trustee commits any negligence in the management of the trust assets. The trustee is not going to do anything here. You're going to tell your trustee, listen, you're just on title as a diversion. You're not going to manage the property. You're not going to collect money. You're not going to do anything. The only thing I'm going to need you for, Mr. Trustee, is when I go to sell the property, you're the trustee of the trust, so you have to sign the closing package. And they have no liability for that either. Okay? So they're signing in a representative capacity on behalf of the trust, and they're not doing anything that would cause them to be sued, so it's not a problem. By the way, who else could be the beneficiary of a trust? Can we have another trust be the beneficiary of the trust? Yes. So for example, if you have a land trust own your principal residence, can we have your living trust be the beneficiary of that land trust? That way we get anonymity on your home, plus the benefit of estate planning and avoiding probate on the living trust underneath. That's a good way to do it. So let's talk about another type of trust, which is similar to a land trust. It's called a personal property trust. What this is essentially a land trust for non-real estate, personal property. So if you owned a car, a bank account, a brokerage account, mobile homes, which are personal property, a note or mortgage on public record, instead of you or your corporation or your LLC being the owner of that, set up a personal property trust and take title in that. It's the same basic thing. It's used to hold title to things other than real estate. You create a personal property trust agreement. It's good for stacking trusts, as we talk about land trusts and living trusts. Also, there's some unique uses for it. So for example, in the state of Arizona, there's a peculiar law that says if you transfer a property into a trust of any kind and you don't disclose the beneficiaries on the name of that deed, then either party to the transaction can undo that for up to a certain amount of time. I don't remember, it's like 2 or 3 years. Now, if you own the property already in your name or your LLC, and then you transfer it to a land trust, you're on both sides of that transaction. Neither of you are going to revoke that, so it's not an issue. But if you're going to buy a property directly into a land trust from a seller who's not related to you, they would have 2 or 3 years to revoke that transaction. You don't want that. So we could stack the land trust by having the land trust be the buyer and the beneficiary of the land trust be a personal property trust, which is also anonymous. And on the deed, we disclose that the personal property trust is the beneficiary, and nobody knows who owns that trust, so mission accomplished. Also for holding membership of LLCs. So in most states, if you have a member-managed LLC, you have to disclose the members of that LLC on your filing documents. What if the member was a personal property trust? No one would know who owns that trust. Mission accomplished. Very creative uses here. Some other creative uses of land trusts include assuming a non-assumable loan, a property exchange, and a joint venture. Actually, in my land trust course, I have literally dozens of creative uses of land trusts, but these are three I want to talk about right now. Assuming a loan. So you create a trust with the seller as the beneficiary and grantor. The seller transfers title to the property to the trust. You are the trustee here. And the reason I say you be the trustee here is because it's confusing to say to a seller, already, you're going to put it in a trust and we're going to do the transaction a little out of unusual way. And by the way, my uncle's the trustee. It just sounds kind of fishy. So I say you be the trustee. It's a lot simpler. And then they're going to assign their beneficial interests in the trust, like we discussed earlier, to you or your LLC. And that effectively accomplishes the transfer of the property, subject to the existing loan, but the lender is not likely to worry about the due on sale clause, which is the clause in the mortgage of the seller that says, if you transfer title, the lender may at its option call all sums due and payable. Remember, it's at its option, it's not automatic. So if the bank sees a transfer from seller to the trust, they're probably going to assume what? That's some estate planning. Now, there's an exemption in federal law. There's 8 exemptions where a lender may not enforce a due on sale with these types of transfers. So one is the creation of a junior lien. 3 is the death, of the borrower. Number 4 is a lease of less than 3 years, not containing an option, which, by the way, lease options do trigger a due on sale. A lot of people don't know that. The lender doesn't find out, most likely because it's not recorded. And number 8, a transfer into an inter vivos trust, a living trust, in which the borrower is or remains a beneficiary. Okay, so, and which does not relate to a transfer occupancy rights. But if the transfer was into a land trust for the benefit of the seller, the lender can't enforce the due on sale there because it's in within exemption 8. What they don't know is if you change beneficiaries from the seller to you, because again, that's not public record. If you get caught, by the way, don't lie, just admit it. It's not fraud upon the lender to simply transfer something subject to the existing loan without telling them. But if you lie and get them to forbear on taking action, that could be. So be careful where you tread there. A property exchange. We place a property in a land trust. The seller places the property in a land trust, and then we're going to swap beneficial interests in those properties. So it's the same thing as you take my property subject to the existing loan, I'll take your property subject to the existing loan. We're trading my equity for your equity, and that qualifies as an exchange. I had a property that I was trying to get rid of many years ago. It was a townhome up in the mountains. I bought a ski house, which was, anyone who's ever had vacation property knows that that doesn't work out very well. Financially, it doesn't. It makes more sense to just Airbnb as you need. Anyway, I get a call from a woman, and she said she has 2 condos in Denver that she'd like to trade me for my condo up in the mountains. And I said, how would we do that? She goes, well, I'll trade my equity in these 2 properties for the equity in yours. You take over my loan, I take over your loan for a while, and then we have an out in a few years that we have to pay off each other's loan. I said, wow, that's really creative. I said, where'd you come up with this? She said, well, I went to the seminar with this attorney, Bill Bronchick, and I said, that's me. That was my seminar. It was really funny. But that's exactly what we did, and it worked out just fine. A joint venture. So A and B want to buy, fix, and flip a property, create a land trust with A and B as beneficiaries. A and B are also trustees, so it takes both parties to sign away the property and split the profits. And then we draft between the beneficiaries what's called a co-beneficiary agreement, which is similar to a joint venture agreement, but it's basically defining this joint venture as co-beneficiaries, not joint venturers. Very, very effective way to do that. I have a great agreement for that. All right, let's take a few questions Carmen asks, can you tell me when buying a home from a seller, how do I put the trust name in? So if you're going to buy directly from the seller, Carmen, let's say a seller carrier or a cash deal, what you could do is just put on the contract 228 Elm Street Trust as the buyer, 221 Elm Street property. And then you just buy it directly. And the beneficiary of that trust is your LLC to start. Or if you're taking it subject to, you can have the seller create a trust for himself, transfer his property into that trust, you as trustee, and then at closing, he assigns his beneficial interest to your LLC. And in the end, it's the same either way, but it's just a matter of how we do it. Jerry asks, why is a land trust agreement better than an LLC operating agreement? That's a great question, Jerry. I said this is a joint venture. So the joint venture between A and B doesn't require an LLC because it's a one-shot deal. Now, if A and B were doing deals regularly, I say form an LLC to be beneficiary of the land trust for each property, same LLC, different land trusts. And then the operating agreement would discuss their roles and relationship. But for a one-off deal, Jerry, A and B just want to keep it simple. The joint ventures between A and B and the beneficiary agreement would discuss, how they split the profits and who's supposed to do what. Good question. Actually, really all good questions. What is fair to pay the trustee? Well, if it's a friend or relative, they're doing it as a favor. So I don't think you need to pay them anything, but if you want to make them feel good, pay them something. Or maybe they're the trustee for your properties and you're the trustee for their properties. Wouldn't that be a nice little, one hand washes the other? Someone asks, Bill, you mentioned in the past it's a good idea for a self-directed IRA to invest in real estate. How does this work for a subject to deal? Can the property still be acquired under a trust? How do these blend in? Excellent question. So the property can be acquired in a land trust, as we've discussed. The beneficiary of that land trust would be your IRA account, or if you have a checkbook IRA, would be the IRA LLC. So very effective stacking of the tools here. Vincent asks, what do you think about using a trust and a family limited partnership to hold assets under a land trust instead of an LLC? I don't like using a family limited partnership directly under a trust. I would do like multiple layers there. So land trust 1, land trust 2, land trust 3, land trust 4 separate properties. The beneficiary of the first 2 is an LLC. The beneficiary of the second 2 is another LLC. And then both those LLCs are in turn owned by a family limited partnership. Okay? If you missed that one, email me, Vincent. I'd be happy to go over that with you. Okay. And then finally here, I would expect my property manager would ask me for a copy of the trust for tax reasons, and we don't want to provide that. I've never had a property manager ask me for it. They just say, what's the trust name and what's the tax ID number of the trust? By the way, what would the tax ID number of the trust be? Who is the taxable owner? The beneficiary. So if the beneficiary is an LLC, you give them that EIN. Okay, same thing when you sell. It's X such and such trust. Tax ID number is the EIN of the beneficiary. By the way, the average lawyer fees is about $500 per trust to create this. That's what I charge in my practice of law. A lot of my clients, I end up setting up a handful. If they have 20 properties, I set up 2 or 3, and then they end up taking it from there, just copying and pasting what I do, because it's not terribly difficult to fill out a land trust agreement. I do have a self-study course called The Step-by-Step Guide to Land Trust on my website, legalwiz.com. It's only $697. As a bonus, I offer document review, because if you do it yourself and you're not in my state or local to me, chances are if you go to a local attorney, they're going to charge you more than $400 to review the trust. So I'm not practicing law for everybody around the country, don't get me wrong, but if you fill out my form and email it to me, I'll tell you whether you filled it out correctly. I can't give you specific advice about your real estate transaction per se, not being admitted to practice in your state, but if it's my form and you fill out my form and I can say, you filled out blank number 2 incorrectly, or whatever, you have a typo here, I'd be happy to do that for you. That's a $400 value. In addition, I'm going to give you a copy of my personal property trust agreement, another $400 value, and you can use that to hold assets like cars, bank accounts, brokerage accounts, notes, etc. So the home study course, the document review, the personal property trust is a $1,597 million value. Today, just $397. And And if you use the code, it's a little early for this, I haven't announced it yet, but MEM for Memorial Day, MEM, I will give you 50% off of that code. So I'm going to type, you can go to legalwiz.com and go to the store, but what I'll do is in the chat, I'll send everybody the link directly to that product. So it's Land Trust, and I'll say code is MEM. Don't use the quotes. That's the code. Okay, so that's in there. Okay, couple more questions. Yes, Jerry, this is all in my land trust course. Carmen asked that. I'm sorry, Carmen. Yes, this is all in my land trust course. It has. Let me tell you what's in the course. It is a course manual. You download. It's all e-course. Download as a PDF. Okay. It has a state-by-state guide in there for each and every state. So you have citations for court cases, the statutes, in case anybody gives you a hard time, that makes them valid in every state, except Louisiana and Tennessee. It's not valid in those two states. I'd still use it anyway. It's not illegal. It's just that it won't hold up in court as a trust. But if you're in court arguing over the trust, your cover is blown anyway. So your LLC would now be the next layer anyway. So, just as an FYI. It comes with all the forms you need for filling out the land trust. I have quitclaim deeds, warranty deeds for every state, affidavits, statements of authority, the co-beneficiary agreement, the exchange agreement, the personal property trust agreement, and a variety of other uses and forms for the land trust. As well as a checklist of everything you have to do to set up and use a land trust. Comes with 4 audio files that was recorded at a live seminar recently, as well as videos that explain all the intricacies of it. It's a tremendous course. It's one of my favorites. It's on my 14th edition. I started the first course in 1996. And if you bought it more than 10 years ago, just buy it here again. It's been updated and you're getting a super bargain anyway. Kyle asks, Jerry asks first, when filing taxes for a trust, do we bypass the trust and file under the beneficiary, i.e. LLC name? The answer is yes. The trust does not file a tax return. Kyle asks, what are the downsides of being your own trustee? If someone comes knocking the door, can you resign and change trustees? Well, they've already figured it out, Kyle, so that is not the best. Now, in Colorado, this is specific to Colorado. Colorado allows you to specifically take title in a trust name, as opposed to some states, they want you to do it in the trustee's name. So John Doe as trustee of the XYZ Trust, dated May 4th, 2019. That's a long, description for the deed, as opposed to XYZ Trust as the buyer on the deed, the grantee, i.e. And then you file a separate document in Colorado called a statement of authority, which says, I'm the trustee, I have authority for this trust, here's my contact information, which is kind of stupid because, anybody could file one of those in theory. Nobody verifies those in most cases. They don't even look at the trust agreement in half the time. Some title companies do, a lot don't. But nonetheless, the statute says the trustee may file a statement of authority. Now, when you go to close, a title company takes that as must, and they're going to insist on recording a statement of authority. But if you take title in the trust name and don't file the statement, nobody knows who the trustee is till you go to sell or refinance it. So that's a case where you might be your own trustee. I do offer the service of being a trustee and resigning. So if you're in a state that takes title in the name of the trust, for $200 flat fee, I'll be your trustee for 5 minutes, then resign and make you the trustee. But on record, it doesn't show you as trustee, it shows me. So if I get an email, I'll just forward it to you. Okay. Hope that answers your question. David Peterson asks, do we use a quitclaim deed to transfer property into the trust? It depends, as opposed to a warranty deed. If you want to make it look like a sale, use a warranty deed, because quitclaim versus warranty doesn't really change the transaction between related parties as far as the warranty of title. It just looks that way as a sale. Now, if you're in a state that has a high transfer tax, like 3% of the purchase price, and you want to file with the county an exemption form to be exempt from transfer tax, then I would use a quitclaim deed because they may not allow a warranty deed in that case. And by the way, putting a property in a land trust does not change anything for federal income tax purposes. So if it's your principal residence, you don't lose your exemption from capital gains. It's not a step up in basis or anything. It's just neutral, as if you still own it. If you have a state in which you have homestead exemption for taxes, where you get a special rate because you're over a certain age, you don't lose that either. And then like in Florida, you don't lose your creditor homestead exemption either. Someone asked, Bill, I saw your presentation on land trust with Chris Haskins' group. Great guy. Are these the same paperwork that they offer? I don't know what he's offering for his course, but he does offer my course, so that's fine. Sorry about that. Of course, it was a spam call of all calls. If the grantor was the husband and wife single member LLC, can one spouse be the sole beneficiary of the trust? The answer is yes. Subject to the, same issues of being your own trustee. Okay. All righty then. All good questions, by the way. You guys are really a great group. So you can go to legalwiz.com, click on store, or use the link I gave you there directly to the product in the chat. Take action now. If you have any questions, you can always email me. Use the code MEM, Memorial Day Sale, which 50% off for a limited time just for this weekend. So everybody, thank you for joining me. It's been a great webinar and great questions. Really appreciate the questions. Appreciate your feedback too. Give me an email and let me know how we're doing. And I'll have a recording of this posted up on YouTube, and then I'll send out an email probably tomorrow. Or you can go to legalwiz.com/webinar, or if you go under free advice, or it's called free stuff, you click on the tab and you click webinars, and you can see the replay of all my recent webinars, as well as this one should be up there tomorrow. And there'll also be information in a couple of days about next week's webinar. Thanks for joining. I appreciate it.